Good afternoon, ABA Division for Public Education social media audience. I am thrilled to be back with you and with our esteemed guest, Professor Steven D. Schwinn of the University of Illinois Chicago School of Law. Professor Schwinn, it is wonderful to be reunited with you.
Kathy, thanks for having me back. It's a pleasure to be with you.
So, Steve, it's been a little while since we've touched base. We have lamented that the decision rate at the court has been a little slow. But over the last 3 to 4 months, what's been your biggest takeaway or the biggest question hanging over your mind when it comes to the Supreme Court?
So I would say the biggest takeaway, Kathy, and this really is from this week's opinions, is you've got a court that is not moving tremendously aggressively in any area. It had a chance this week, as we'll talk about in a second, to move aggressively in two opinions, and it declined to. And these were two big ones, two blockbusters of the term. And so I would say you've got a very cautious court.
Great. So as you mentioned, there's two big cases that we heard from decisions on Thursday. Before we talk about those two, I do want us to quickly mention the third case because I think it's getting a little bit hidden in the headlines. Nestle Cargo versus Doe. Steve, tell me, did this decision just surprise you at all? And what exactly was the court doing here?
Didn't really surprise me. So this is a case, Kathy, where 6 individuals from Mali brought a claim against Nestle and Cargill and some others for trafficking them and then using them as slaves in the production of cocoa for Nestle's chocolate in West Africa. They brought the claim in U.S. court under a statute called the Alien Tort Statute, the ATS, the Alien Tort Statute, that allows an alien to sue for a tort that's a violation of international law. We've seen advocates in recent decades try to use the ATS to enforce human rights against corporations, for example, like Nestle. And what the court has said in its most recent cases is that the plaintiffs in ATS claims have to establish a connection between the defendant and the United States and what the defendant is doing and the United States in order to avail themselves of the jurisdiction of US courts, to get their foot in the door in the courts. And that's exactly what the court said in this case. The court said, unless the plaintiffs can establish a connection between the defendant's offending actions, basically slavery, and the United States, the US courts don't have jurisdiction under the Alien Tort Statute to hear the case. And so while it was a disappointing claim because the courts are not going to rule on this fundamental violation of human rights, it really wasn't a surprise.
Yeah, I think you're spot on that this case was not totally shocking. I think the facts of it, and when you hear, as you mentioned, the story behind it, it seems shocking that this is one that the U.S. courts are not getting involved in. But this ruling from the U.S. Supreme Court sort of trends with, I think, where we've seen the court going in some of these big business and corporate law cases, and them really falling back to sort of basic civil procedure notions, and allowing for some protection and some immunity for some corporate actions here. I think it trended exactly where folks thought it would.
Yeah, totally agree. And you raised another point, Kathy, that I think is spot on, and that is that this is consistent with this particular court's trend of favoring corporate rights.
Yeah, for sure. So let's dig into some of the meatier cases or potentially some of the surprising cases that we got on Thursday. Steve, can we start with California versus Texas in the Affordable Care Act case?
Let's do it.
All right. Yeah, jump in.
We covered this, Kathy, earlier in the term around the oral argument time. And just to remind viewers, this was a case where the state of Texas and a couple of individuals and a number of other states sued under the Affordable Care Act to rule that the so-called individual mandate or universal coverage provision of the Affordable Care Act was unconstitutional. And the reason why is because you remember back that the court ruled in a case called NFIB versus Sebelius that Congress had authority to enact the universal coverage provision under its taxing power. And that was because if a person didn't get insurance, the IRS would collect a tax penalty from the person. Well, Congress after it was unable to repeal and replace the Affordable Care Act, decided to zero out the tax penalty for the universal coverage provision in anticipation then of exactly this kind of litigation, challenging the provision as exceeding congressional authority under the taxing clause, because now the penalty was zero. There was no possibility that the government could raise revenue from a violation of this provision, and therefore it couldn't be justified under Congress's taxing power. But the plaintiffs went a step further. If we'll remember from our earlier discussion, the plaintiffs said that this provision, the universal coverage provision, was not severable from the entire rest of the Affordable Care Act, which includes all kinds of different provisions, including community rating, non-discrimination, even provisions like young people get to stay on their parents' insurance until age 26, which would have meant that if the universal coverage provision failed, potentially the rest of the act could fail as well. Well, the Supreme Court kind of, took a pass on the whole merits issue. What it said was that the individuals in the states lacked standing to bring the claim. In order to get your foot in the door, a plaintiff has to show that they've been injured, that the defendant's action caused the injury, and that a court could redress the injury. And what the court said here was that neither the individual plaintiffs nor the states were able to trace their injury to the government action, or trace the government action to their injury in a way that would show causation here. The reason why is because the two individuals, they were complaining about this provision, but nobody was going to enforce the provision against them. There wasn't going to be any harm. And so they couldn't show that even if they felt like they had to get insurance, that there was any enforcement power behind that that would cause them harm. As to the states, what the states were complaining about is that they were seeing increased costs from other provisions of the Affordable Care Act, not the universal coverage provision, but from other related provisions. And the court said, no, it doesn't work that way. If you're going to be harmed, you have to be harmed by the provision that you're complaining about, not some other provision. And so they lacked standing as well. Basically, the case kind of fizzled out. I don't think it was a huge surprise on standing grounds. Although there was a lot of worry that the Supreme Court would come to the merits issue and strike the universal coverage provision and potentially even other sections of the act. Turned out not to come to pass. The case fizzled.
Steve, is this one where the court, we sometimes see it saying, even if there is standing, we're still going to address why we would rule the way we're ruling, or rule in favor of the party that we're ruling in? Is this a case where we got that? Or was it just standing?
Yeah, terrific question. We didn't get it from the majority. So the majority said, well, look, we don't have to address the merits because the parties lacked standing. Now, the practical effect of that is that the Affordable Care Act stays on the books in total. The whole thing is still on the act as if this case never occurred. Now, the dissent, Justice Alito in dissent, did address the merits. And what he said is, look, not only is there standing in the case, but the individual mandate, the universal coverage provision, is no longer constitutional now that it's zeroed out. And other sections might not be severable, and they might have to fail as well. So he took a much more aggressive stance, but he was in dissent.
Steve, I was wondering if you could talk a little bit about this idea of third-party standing. And I know Justice Breyer in the majority opinion mentions it a little bit, and then we see Justice Alito in the dissent talk about it. And I'm asking you in particular because I think the last time I remember seeing a fair amount about third-party standing was dealing with abortion access clinics and whether or not doctors have standing in those cases. And how does that play out here, and what is third-party standing?
Yeah, so third-party standing is the idea that you can't bring a claim on behalf of a different person who was injured. So, Kathy, for example, if I'm injured by somebody's action, you can't bring the claim on my behalf. I actually have to bring that claim myself. And the sort of paradigmatic case that we talk about in law school is the ability of a doctor to bring a claim on the right to abortion on behalf of the doctor's patient. The Supreme Court has carved out a kind of exception to standing doctrine that allows a doctrine to bring that sort of third-party claim. But as a general matter, you can't bring a third-party claim. Now, that plays in this case because here you've got the states lodging a complaint that they're being injured in a way, again, that is not directly traceable to the individual mandate, the universal coverage provision, but instead other provisions of the act. Now, there may be somebody out there who potentially is affected by the universal coverage provision, but they themselves would have to bring the claim. It couldn't be the state, or it couldn't be the individuals in the case who weren't affected by that. And similarly, if the state of Texas wants to complain about other provisions in the Affordable Care Act, then it has to sue under those other provisions. It can't sue to stop the universal coverage provision. In other words, kind of a different way of thinking about this is that the plaintiff and the claim that they're bringing has to line up with the way that they're suing. There has to be a match there, and there just wasn't in this case.
That's a great analogy and a great visual for this case, I think. So this is the third direct challenge to the Affordable Care Act that we've seen make its way up to the Supreme Court. The Act's now been in place for over a decade. We have NFIB versus Sebelius, I think is itself more than 10 years old. Steve, I bet you were hoping I wasn't going to ask you to put on your prediction hat since we are at the end of the term, but if you can dust off that prediction hat, do we get more ACA challenges? And what does this mean for the future of the Act and the future of the Act before the court?
Kathy, I know the word on the street is that the ACA now is here to stay, and that opponents of the Affordable Care Act really don't have any more tools in their tool chest. We're undoubtedly going to see more claims against the ACA. I don't have any idea what they're going to be, but we will undoubtedly see additional claims against the ACA in court and continued attempts to take it down through the legislature. I predict those will all be unsuccessful. And with each passing year, each passing Congress, and each passing court case, the Affordable Care Act is further and further entrenched in our healthcare law. And I think it's here to stay. The Biden administration is already talking about ways to strengthen it now that it has been essentially upheld by the Supreme Court in these three cases.
Yeah, I think you're spot on. I think the act itself is so massive and so complicated that there's enough nuances that this will be one our kids will be talking about, and there will be litigation. And you look at any sort of broad federal system or federal act, and these cases last forever. So I think you're right that this is not the last time we'll see an ACA case, but I think it is a further statement that the act and the system that it has created will be with us for the foreseeable future at the very least.
Well, and Kathy, moreover, Kathy, it's actually really good public policy. Like, it has provided insurance options at an affordable rate for all Americans, and therefore achieved its objectives. And people really, really like it, and like some of the provisions that we don't often associate with the Affordable Care Act. So, it's politically popular. It's doing its job. I think it's going to be around. We've talked about this before. I think this is such a wonderful case study for example, a high school civics class that can talk about the interplay between public policy, politics, constitutional law, and look at the intricacies of the Affordable Care Act and the way it operates as a matter of public policy, health economics, and economics generally to achieve its goals. It really is rich with material.
That's a great point. And I'll transition us by saying another case that's potentially rich with material for a high school civics teacher is Fulton versus the city of Philadelphia, which was the third case we got Thursday morning. Steve, can you talk to us about the facts of this case? And I think the court's decision was pretty nuanced and pretty technical. So we may need to spend some time talking a little bit about the precedent that got us here and what was happening in Philadelphia.
Absolutely. Yeah. And a totally in the weeds opinion in an effort to avoid a much larger question. So Catholic Social Services contracts with the city of Philadelphia to help out with their foster care system. And in particular, CSS recommends and certifies families for placement in their foster care system, certifies families as foster care qualified in the program. Catholic Social Services said that it would not certify families that are headed by a same-sex couple, although it would refer those certifications out to another nonprofit. And the city of Philadelphia came back and said, well, you can't do that. That violates our non-discrimination policy. And if you continue to maintain that position, we won't contract with you anymore, which turns out to be a really big deal. CSS has a long history with the city of Philadelphia and its foster care program. By all accounts, has done a wonderful job over the years, but won't make recommendations to families with a same-sex couple. So the city of Philadelphia said, we won't continue your contract. CSS then sued, arguing that the city's action violated its rights under the Free Exercise Clause of the Constitution. And here's where, as you suggested, some background might be helpful. So when the court considers Free Exercise Clause claims, it considers them in one of two ways. The first way is a claim against a government action that is neutral with regard to religion and broadly applicable. It applies to everybody. It's neutral with regard to religion on its face, but it nevertheless has what the court calls an incidental effect on religion. Now, when a government enacts a law like this, the court applies a test we call rational basis review. It's an extremely deferential test. And what it means in most cases is that the court is going to uphold the government action against the free exercise challenge. So that's one way the court views free exercise cases. The other way the court views free exercise cases is where the government actually targets religion for mistreatment. When the government targets religion, the court applies a test we call strict scrutiny, which is sort of at the exact opposite end of the spectrum as rational basis review. Under strict scrutiny, the government has to show that it has a compelling government interest and the government action is necessary to achieve that compelling government interest. Most government action under strict scrutiny fails. And so how the court categorizes the government action is critically important at the outset. Now, in this case, not only did the court have to categorize the government action, but CSS was also challenging that first test itself. This test the court crafted in a 1990 case called Smith. And Smith has long been the target of criticism, and more in recent years. And there's been an effort to get the Supreme Court to overturn Smith and to treat these broadly applicable, religiously neutral laws, not under rational basis review, but under some higher standard of review, most likely strict scrutiny. So that issue was up in this case as well. What the Supreme Court said was this, the city of Philadelphia here was actually not using a broadly applicable, religiously neutral law when it said that it wouldn't contract with CSS. And the reason why is because it was relying on a provision in the contract with CSS that said, CSS, you can't discriminate by sexual orientation, but the commissioner can provide an exception to this non-discrimination at the commissioner's sole discretion. And the court said, because of that exception language, we can't treat the city's non-discrimination clause in the contract as religiously neutral and broadly applicable, basically because it gives the commissioner an out. And so therefore, we're not going to treat the case under this lower level Smith test, the first test we talked about. Instead, we're going to treat it under the higher level test as if the government were targeting religion and apply strict scrutiny. Now, this move allowed the court to skate around the issue of whether Smith is still good law and whether it ought to overturn this lower level test. And so the court didn't address that. Instead, what it did was apply the higher level test, apply strict scrutiny, and say the government didn't have a compelling government reason for providing this term in the contract and telling CSS that it wouldn't contract with them anymore. And so therefore, the government's action violated the free exercise clause. I know that was a lot, but you're exactly right. This was a technically detailed case, and I think it's important to understand those details.
So, Steve, if I'm hearing you correctly, is this the situation where if that exceptions portion of the contract was not there, that this would have been a very different case?
Quite possibly. I only hesitate because I think the court really was reaching here
Yeah.
to not deal with the Smith question, and they might have found a different way not to deal with the Smith question.
And that's why I asked that, because I think that exceptions gave them that out,
Yes.
but I don't know if that exceptions would have to exist in every case that would come forward with a similar fact pattern for them to have found, for the result to have been the same. We'll say that.
I think you're exactly right. But Kathy,
Yeah.
remember, in the Masterpiece Cake Shop case, we had a similar kind of move by the court, right? It avoided the core Smith question by saying that it was the Colorado Civil Service Commission that discriminated, targeted Masterpiece Cake Shop in some of the statements that some of the commissioners made in hearing the case. And in that way, they skated around the Smith issue as well. There's another reason why what you raise is really important. When the city of Philadelphia now considers how it can revise its contract with CSS, it is surely going to take out the exception clause, right? And so at that point, then the city again will terminate its contract with CSS, and we'll see this case come back up through the court system on exactly the facts that you're suggesting.
I think the lesson here for any lawyers watching is this may be one of those situations where a shorter contract is better than a longer one, for sure. Steve, can you talk a little bit about the vote breakdown with this one? Who was on which side, and where did the counts lie?
Yeah, and this is kind of interesting too, because political conservatives now are counting on the composition of the court and the 6-3 majority that conservatives enjoy to overturn Smith. And I think they have their vote count right. But in this case, we had Chief Justice Roberts align with the 3 progressives and with Justice Kavanaugh and with Justice Barrett in the majority opinion. What was interesting then is that Justice Barrett wrote separately a concurrence joined by Kavanaugh and in part by Justice Breyer, arguing that, we really do need to take a look at the Smith case, but then going on to say, it's not clear that the answer is to overturn Smith and replace it with a strict scrutiny test. There may be a different way to approach this, which is really interesting because now what that suggests is that there are 2 conservative votes and potentially 1 progressive vote on the court to take a kind of different look at what would replace Smith. And then you had Justice Alito and Justice Gorsuch and Justice Thomas. Justice Alito wrote a dissent, a concurrence, but it actually read like a dissent.
It really did read like a dissent.
And Gorsuch writing separately as a concurrence, and the 3 of them joining each other, arguing that not only should the court have considered the Smith issue here, but it should have overturned Smith and applied strict scrutiny.
Steve, I'm wondering if you can place this in a little bit of a broader context of what we've seen in the last 18 months with some of the other religious organizations challenging COVID restrictions. And we haven't really talked about those cases in too much depth since they weren't granted oral argument. But I wonder if there's some threads that we can see either running through these cases or potentially bundling them all together into one larger theme.
Yeah, absolutely. So what you're referring to is what we often call the court's shadow docket, where the court rules on cases outside of its ordinary appellate certiorari procedure. We saw a handful of cases go up to the Supreme Court challenging state restrictions based on COVID under the free exercise clause. And the challenges more or less went like this, that the state restriction prohibited religious gatherings in a way that it didn't prohibit similar secular gatherings and therefore violated the free exercise clause. And the court time and time again in these cases ruled in favor of the religions, which given the court's doctrinal trend going back now several years, was hardly a surprise, right? This is a court that is leaning more and more in favor of religious rights, which is why I think that at some point we are going to see the court revisit Smith. It's just a matter of when that will happen.
Great. So Steve, what is left on the docket? What are we looking for in the coming weeks, and what are you most anticipating?
Yeah, so, well, let's see. So we have the cussing cheerleader case, right? Which is going to be a real big free speech case that that we'll be taking a look at. And what else is big left on the court to rule, Kathy? I know there are a number of
Arizona voting, the Arizona Voting Commission case would be another one that I think we'll be watching closely. And then I'm watching some of the Fourth Amendment cases that are still out there. I think particularly for the teachers who may be joining us today, you know, Fourth Amendment is a bread and butter, great topic to have in classrooms. And I'm wondering if by this summer, when we do reflection on what the court has done with the Fourth Amendment, if there's some really interesting new narratives that have come out on how the court assesses Fourth Amendment rights as they apply in the car or the home, or as they may dictate police interactions with individuals in the community. I think there could be something really interesting there.
And those are always fantastic cases. I mean, those are really go-tos, right, in the classroom. Because they so engage students. I completely spaced on the Arizona voting case, the Brnovich case, though, Kathy, and I do want to make a pitch for that as well, just keeping our eye on it. I really think this is going to be a very significant voting rights decision, especially given where the court has gone with voting rights, going back to Shelby County and essentially erasing Section 5 of the Voting Rights Act from the act itself. And given everything else that we're seeing in terms of challenges to election law generally, and even reconsideration of the 2020 election in places like Arizona, right? This is going to be a big one.
Yeah, I am curious when we put the sort of final review on this entire term, whether it's one where we see the court carving out nuances or small things to grasp to, as we talked about today, the ACA case going out on standing, Fulton being on that contractual exceptions issue, the cheerleader case, I think is pretty fact specific. Or is it one where we see some big trends coming? And I think the Brnovich, the Arizona case is one where we may see a significant ruling there. I think you're right on that.
Yeah, so more to come, right?
Yeah, more to come. And so with that, Steve, as always, I'm thrilled that we're back together. We've got some decisions to dig into before the summer really hits us. And to our audience, I will make sure that Professor Schwinn joins us and helps unpack all of these cases in the coming weeks. Thanks, Steve.
Thanks, Kathy. Take care.